Hi, my name is Jonathan, and I'm one of the lawyers at Varity Law. One question I'm asked quite often is whether a client's will is valid. And there are several factors to consider before I can answer this question. Let's go through a checklist. First, the will should be in English or French, but not in another language. Second, the will should be printed or handwritten, though printed is preferred as some handwriting may be hard to read. Third, the person who makes the will, called the testator, must be conscious, of sound mind, and not be under duress when signing the will. So it's best to make your will early and not wait until you may be in a hospital or have reached a very old age. Fourth, when the testator signs the will, two witnesses must be present and sign at the same time. The witnesses cannot be the beneficiaries or their spouses. So if George is giving all of his assets to his daughter, then his daughter and his son-in-law cannot be witnesses. Fifth, and this is what most people miss, at least one witness must swear an affidavit in front of a licensed lawyer, and this written affidavit must be submitted with the will when applying for probate. This is the only thing that can be done after the will is signed, provided you can still find the witness and the witness is conscious enough to do the affidavit. Now, those 5 rules are mandatory requirements for your will to be valid. However, there are 3 other things that separate a basic will from a good will. First, the will should be logically sound and have no conflicts in law. A common example is that a married couple have a joint bank account, but their will states that the proceeds from the bank account go to their children, not each other. This is a conflict. Or a more complex example, a business owner's will says that his company will go to his son, but in his business documents, there are share transfer restrictions that prevent this from happening. Second, the will should have helpful clauses such as a bond exemption clause or a divorce protection clause. We'll talk about these in more detail in our future videos. Lastly, the will could include some tax or estate planning clauses that help to reduce legal fees, interest penalties, and taxes payable down the line. Overall, a good will can significantly reduce the time it takes for beneficiaries to receive their inheritance. But does your will contain the 5 mandatory requirements and have those 3 helpful clauses? If you have any questions, we invite you to click the link below and book your first free consultation with us. Thank you.